Hey guys, this is CMA Deepika Bhugra Prasad, Insolvency Professional. I welcome you to my new series, Quick Takeaways from Recent Judgments, the ABC of IBC through the lens of our honorable courts. So I today bring you the case of Vashisht Builders and Engineers versus Trishul Dream Homes and another, which was decided on the 20th of May 2025. Now, what are the facts of this case? The RP filed an application for approval of the resolution plan. The AA asked the RP to file a compliance affidavit along with the audited financial statements of the CD. The adjudicating authority dismissed the application seeking approval of the plan by order dated 23rd of April 23. The quick facts further include that there was no opposition to the resolution plan, nor any objection was filed by any stakeholder objecting to the resolution plan. The COC, RP, and SRA were all aggrieved by the order, rejecting the resolution plan, and thus filed appeals. The AA, however, has given certain reasons in rejecting the resolution plan. Let us understand the judgment delivered. Now, what were the issues before the Honorable NCLAT? First was the clause of the resolution plan in increase of the CIRP cost. The creditors and class included the home buyers, which consisted the majority of the COC, and voted with a 91% vote share in favor of the resolution plan. Any increase in the actual CIRP cost from the proposed CIRP cost shall be paid out of the amount proposed to the unsecured financial creditors proportionately, and any surplus further from the proposed CIRP cost shall be infused in the construction of the project. In a nutshell, the resolution debt amount shall not be changed with the increase of the CIRP cost. The AA observed that this clause does not appear to be rational. However, the Honorable NCLAT held that the said provision cannot be said to be irrational. Further, there was a clause related to valuation. The value of the assets of the CD were asked for to assist the COC to take decisions. The order impugned does not show that any stakeholder has raised any objection to the valuation done by the valuers. The Honorable NCLAT held that when no objection to the valuation conducted of the CD was raised by any stakeholder, it was not open for the AA to enter into the issue of valuation of the assets of the CD, and thus, based upon this, reject the resolution plan. Further, there was the issue of statutory liabilities as shown in the balance sheet of the CD. The public announcement was made, and the proviso to Regulation 6A contains an exception that where it is not possible to send a communication to creditors, the public announcement made under Regulation 6 shall be deemed to be communicated to such creditors. The SRA, as per the order of the AA, has filed a compliance affidavit. The Honorable NCLAT held that the AA, without adverting to the compliance affidavit, has held that there is breach of Regulation 6A. Thus, this observation of the AA is unsustainable. Further, there was a scope of intervention or by the AA with the commercial wisdom of the COC. The issue, the provision of Section 31(1), which required the AA to scrutinize the resolution plan, and if the resolution plan meets the requirements of Section 30, subsection 2, it needs to be approved. The Honorable NCLAT holds that the AA has failed to point out any violation in Section 30, subsection 2, on the basis of which rejection of the resolution plan can be sustained. Further, there was a clause related to PUFE. The plan provided that all the recoveries from the avoidance transactions shall be exclusively for the benefit of the RA, and the financial and other creditors shall not have any rights on the ground that RA has proposed to settle all the claims in full. The Honorable NCLAT held that the above provision of the resolution plan, having been approved by 91% vote share, it cannot be considered to be irrational, and the AA committed error in finding fault with the said clause. So we conclude that all the appeals were allowed, and impugned order dated 23rd of April 23 was set aside. The resolution plan submitted by the SRA is thus approved. So friends, here it is, a judgment supporting the resolution plan approved. So I hope that you find this interesting as well as helpful. So thank you guys for being with me here today. This is Deepika B. Prasad signing off, and I will catch you in the next judgment shot. Thank you.